You're listening to 15 Minutes, where we feature community leaders sharing what the rest of us should know but likely don't.
Hi, Chad Franzen here, one of the hosts of Share Your Voice, where we talk with top-notch law firms and lawyers about what it takes to grow a successful law practice. This episode is brought to you by Gladiator Law Marketing, delivering tailor-made services to help you accomplish your objectives and maximize your growth potential. To have a successful marketing campaign and make sure you're getting the best ROI, your firm needs to have a better website and better content. Gladiator Law Marketing uses artificial intelligence, machine learning, and decades of experience to outperform the competition. To learn more, go to gladiatorlawmarketing.com, where you can schedule a free marketing consultation. My guest today is Susan O'Malley, partner at O'Malley Tunstall. Her expertise spans various practice areas, including workers' compensation, personal injury, and medical malpractice. Graduating cum laude from the University of North Carolina at Charlotte, she pursued her legal education at the University of North Carolina at Chapel Hill. She was one of the lawyers who drafted the first Social Security specialization test in North Carolina for the state bar. As a North Carolina State Bar certified specialist in Social Security disability law, she played an integral role in the formation of the specialization committee and has been involved in landmark cases such as Joyner versus Barnhart and Hines versus Barnhart. Her dedication to advocacy is further evidenced by her active engagement with the organizations like North Carolina Advocates for Justice and the American Association for Justice, where she has held leadership positions and contributed significantly to their disability law sections. Susan, it's great to have you today. How are you?
Thank you. I'm doing well, Chad. How are you doing?
I'm doing great. Thank you so much. Hey, so tell me, how and when did you know you wanted to become an attorney?
Actually, pretty darn young. We have attorneys running throughout our family. I have an uncle on my mother's side. I had an aunt on my father's side. And I don't know why, I kind of assumed in my head I would be an attorney. And my sister's an attorney and her husband's an attorney. So it kind of runs rampant.
So you decided that pretty darn young. What was your path toward getting into the legal industry and how did you get started?
Well, of course, college, law school. I kind of went into law school thinking I wanted to work in criminal law. And my first job out of law school was with Jimmy Keel in Eastern North Carolina. And he had a variety of areas, the workers' comp, the medical malpractice, personal injury, and Social Security, which I did all of that. But I kind of found my niche in Social Security disability. And although that was a smaller area of practice when I started with Jimmy, I grew that practice and I have enjoyed helping people in that way.
Great. So how did you kind of find that niche in Social Security disability law?
Part of it was Jimmy's overall philosophy. If you're right, keep fighting. So I would believe I was right for my client. So I would appeal it beyond the hearing level and I would appeal it into federal district court. And I found that I had a good understanding of how Social Security laws work and how it should be applied to my client's case.
So you're the first person I've ever spoken to about Social Security disability law. Tell me about maybe some common misconceptions and just some elements that people should know.
First thing, don't give up. It's a very long process, a very frustrating process, but don't give up. You get typically denied at the application, typically denied at reconsideration, and have to go to a hearing. And it takes a while to work your way through that. So the biggest thing is to not give up. The other biggest thing is get the medical treatment. Medical treatment is kind of like the foundation of the house you're trying to build. What you say needs to match up with that medical treatment. And if it does, then you've got a strong case. If it doesn't, you don't have a strong case. And the third thing is common sense and Social Security sense are not the same thing. So that's where an attorney can be very helpful because they'll understand how Social Security is looking at your case, where that doesn't necessarily make any common sense to you as to how they should look at it.
At what point should somebody consider using an attorney? Right away or after being denied once, or what would you recommend?
You know what I tell people is the attorney can help you at any point. They can help you at the application level. They can help you with the first appeal. They can help you at the hearing level. If you're comfortable filling out paperwork, getting that information to them at the application level, I would certainly encourage somebody to do that on their own and see if they're the exception to the rule and they get approved. It's possible. But once you get that first denial, you have to remember you only have 60 days to appeal it. And if you let the 60 days come and go, you have to start over from the beginning with a new application. So certainly if you get that first denial, that's when you want to get help, and you want to get help before the time runs out to appeal. So an attorney can be helpful at any stage, but if you're comfortable and want to try the application and see what happens first, that's always fine.
Can you kind of elaborate on your thought that Social Security sense and common sense are not the same thing?
For instance, if you have a medical condition that has not been diagnosed by a doctor you went to on your own, it cannot be considered. So let's say you put in your application and the Social Security doctor diagnoses you with a condition. If you haven't gone to your own doctor and gotten that independent diagnosis, they will not consider that medical condition. They don't have to consider whether you would be hired for a job. What they're looking at is, could you do the job? Not whether you'd want to do the job, not whether you would get paid the same amount of money that you did for your past work. So for instance, a very common sense approach is, well, I have to take this medication and nobody would hire me on that medication. That's common sense. That's not Social Security sense. They're looking at, could you do that job on that medication, not whether you'd be hired by anybody. So again, that's very confusing because it makes no sense.
Sure, sure. So, hey, can you tell me about maybe some memorable cases or a memorable case you worked on? I mentioned you were involved in some landmark cases, Joyner versus Barnhart and Hines versus Barnhart. Can you tell me, is there a particularly memorable case you've worked on, and are those one of them?
Well, let's talk about Hines. There had been a series of cases prior to Hines where they had to, other attorneys were making Social Security acknowledge that pain by itself can be disabling, and that if you had a medical condition that could reasonably result in pain, then your subjective testimony, what you have to say about your pain, has to be given weight, as opposed to requiring medical proof, requiring an x-ray, requiring something objective. You have to establish that you have that medical condition, but then it can be disabling because of pain. So Hines was one of those cases where it was a pain case. And by that, I mean, he had the medically diagnosed condition. There was no argument about that. But one of the reason that it was denied at the initial level was he had no end organ damage. Well, certainly that would be an objective sign of the seriousness of the medical condition, but that's not required. So his testimony regarding the difficulty with his stamina, the difficulty he had with the flare-ups with his condition, should have been accepted evidence of pain, and there was actually nothing that contradicted that he had those problems. And in fact, in the very report that the judge used to deny the case initially, even the doctor put in the fact that end organ damage doesn't exist doesn't mean they don't have severe symptoms. So that was, again, kind of and they called those prior pain cases Hyatt cases, and that was reestablishing that Hyatt was in fact the law, and that once you've established your medical condition, your subjective evidence, what you have to say about your health condition, has to be given properly.
Is that the most memorable case you've been involved with?
Well, yes. I won at federal district court. Now, I have no proof of this, but my oldest brother was a reporter at the time and knew the U.S. attorney that lost to me. And called him up and laughed at him for losing to his little sister. And the case got appealed by the U.S. Attorney's Office to the Fourth Circuit Court of Appeals. So that's the last stop before the Supreme Court. So I was going up to the Fourth Circuit Court of Appeals, driving up to D.C., going and arguing in front of that panel to defend the win I had below, and I successfully defended that win. So that makes it very memorable.
Sure. What do you think makes you or has made you successful in cases like that?
Certainly understanding the law, but also tenacity. It's easy to give up. It's easy to say, okay, I'm just not going to take it to that level. I'm not going to practice that way. But this was one of those cases where the way I interpreted the law and it should have been applied was being decided wrongly, and goes back to Jimmy telling me, if you think you're right, do what you need to do. So that tenacity to not give up and to push it when I know that my client's case should have been approved.
Has the field of Social Security law evolved since you began practicing?
It has. It obviously always regulations change and different things like that. I would say now it is harder to get disability, and that's where the attorney can come in and be even more helpful. I think there has just been overall sort of a tightening down on approvals. So again, understanding how medical records are going to be looked at. For instance, many years ago, I had a client and I was reviewing their records, and the doctor had put down that the client had taken up panning for gold as a hobby. That doesn't sound very disabled. Turns out you could mail order dirt and sift through it at your kitchen table. Very different idea. But again, rather than cut and run on that case because I had seen they had taken up panning for gold, I called the client, I asked them what was going on, and then we could put context to that record. So a lot of times for clients, I'm giving them the advice of, remember that what you're saying is being written down. Don't use words like okay, fine, or good when the doctor asks you how you are. The doctor understands that you mean you're no worse, but then it looks like you have no complaints. So I tell my clients, complain, don't whine. Nobody likes a whiner, but you've got to complain. You've got to get that documented. No matter how many times you've said that, if it's a consistent problem, Social Security is going to expect it to show up consistently in your medical records.
How do you kind of, given that it's kind of evolving, how do you stay updated with the latest developments and trends?
Well, of course, there's continuing legal education. I belong to the Social Security section for the North Carolina Academy, and there's online education classes. There's also just in general being part of that community of lawyers, and we communicate regularly about our cases, about what we see coming down the line. So it's a very active online community as well.
Can you tell us about your involvement in the formation of the Specialization Committee for Social Security Disability Law?
For the state bar, I was approached by Charles Hall to be on the initial committee. And the committee, we went through everything. We went through, if you're applying, how long should you have been in practice? How much of your practice needed to be Social Security specific? How much CLE were we going to require? Also, you have to have a certain number of recommendations from the professional community. And then we literally drafted every single question on the test. And then when the first test was taken, we graded every single question on the test. But there are lots of because Social Security is a national program, it's a federal program, all the laws in the different states are actually the same. There are national programs for recognizing specialists, but not Social Security. So that was part of what had been worked on, is to get a Social Security disability law specialty specific to North Carolina because that helps clients understand the level of knowledge that a practitioner has. Social Security, again, is unique in the fact that until you get into the federal district court level, you don't have to be an attorney to represent somebody in Social Security disability. So we wanted to make sure that we had a way of reassuring people who came to us that we actually had the skill and the experience to make the difference.
How do you kind of handle the emotional weight that comes with representing clients who are maybe are stressed out or whatever involved in Social Security disability cases?
That's certainly difficult. Um, you certainly have to listen, but you also then have to educate. And again, that goes back to what I was saying, common sense and Social Security sense are not the same thing. So they're asking you questions like, well, if I'm taking this medication, I can't get hired to do that. And I say, I understand that, but that's common sense. That's not Social Security sense. So we need to go back and break down why you couldn't do that job regardless of the medication. So you certainly have to listen, understand how difficult it is, but then also try to help them understand how we can move forward with a Social Security disability case and what is going to help Social Security understand their disability.
Did you kind of have to learn, like, is there like a fine line between being empathetic and forthright in terms of conveying what your client needs to hear, regardless of their emotional state?
Yes, you do have to tell them the truth.
Hmm.
And the example I would use is very early on when I practiced, substance abuse was actually a disability. And that got removed from the system. So when I go through records, if I see the records are noting substance abuse, I have to deal with them straight up on that. And there's always some sort of, I was self-medicating this, all sorts of reasons. It's like, okay, I get that. However, if the substance abuse was a reason you are not able to work, the judge is not allowed to approve you. So first of all, we need to be honest. We don't need to sugarcoat it, because if you sugarcoat it, then the judge is going to simply assume you're sugarcoating everything. And we need to say what you're doing, how much you're doing. Now, there's a couple of ways to address that. Some people have approached the point of no return. What I mean by that is it might be somewhat helpful if they stop the substance abuse, but it's not going to undo the damage, and their disability is going to remain regardless. Or to show that there are periods of time where they were not using substances, but the problems remained as severe as they are when the substances are being used. Obviously, not using substances is the best action. And I encourage that, and I encourage them to go to their doctor and get the help that they need and to follow their doctor's recommendations. But you have to tackle that head on, and you can't sugarcoat it.
What do you find most rewarding about this field?
That I'm absolutely making a day-to-day difference in my clients' lives. Getting their disability approved means that they can afford the daily living expenses. But what also means is that they will become Medicare or Medicaid eligible, and they will be able to afford their medicines. They'll be able to afford going to the doctor. They'll be able to afford going to a specialist when perhaps all they could afford was their general practitioner. They won't have to choose between medication and food or medication and the power bill.
In terms of what you do day to day, what do you enjoy most about, whatever tactical or what, tasks that you do on a day-to-day basis? What do you enjoy most?
Certainly, I love kind of discovering something that I think really gets our foot in the door strongly. And what I mean by that is if the doctor is either willing to write a disability letter or fill out a form, it has to be more than John Doe is disabled. That means nothing to Social Security. But if the doctor has treated the patient for a significant amount of time so that they're familiar with their conditions, they run the appropriate tests, And they have given specific restrictions like no lifting over 5 pounds, no standing for more than 20 minutes at a time, or have verified the need for a walker, a cane, a service animal. Those are the sorts of things that I can use to try to get Social Security's attention in a disability case before the hearing level. If I get something like that, I will write a letter to Social Security summarizing why these elements make this a case you can approve without making you wait for a hearing. The other thing I enjoy is hearings when issues come up that either I was expecting or was not expecting, but I'm able to run with it and use my knowledge to show why those issues don't stand in the way of an approval.
How did your firm, O'Malley Tunstall, how did that come about?
That was a journey. I came out to work with Jimmy Keel in 1995. It was Keel Law Offices. I became a partner when I turned 30 years old. Joe Tunstall joined us later. Joe was Jimmy's nephew. He had gone to law school. We were Keel O'Malley Tunstall for a while. And unfortunately, Jimmy passed away in an unexpected car accident in 2010. And Joe and I looked at each other and said, do you want to keep going? We both agreed on it. We shook hands and we dug in and made our way through that. And Joe and I have been working together ever since.
Okay, great. How what is it like a challenge that you face as a result of being a business owner as opposed to just challenges, a legal challenge that you that you kind of didn't expect maybe when you first started?
Nobody teaches you how to run an office in law school.
Mhm.
They teach you the law. So learning how to deal with personnel, learning how to treat people fairly, but at the same time, you have to get productivity from people, making the hard decision as to who to let go, even the decision, learning how to make better decisions as to who to hire, as to what things we need to ask, as to what things we need to know before we just hire somebody. And then figuring out the financial end, how to deal with the banks appropriately. What are the banks looking for? How do we make sure we have cash flow so that everything stays open? Those are and how do we deal with the IRS and what's the right legal format for our firm to exist in? Initially, we existed as a partnership, but eventually we've now morphed as you go on into an S corp, and that's nothing you learn in law school. That's been a lot of seat of the pants.
Yeah, I bet. Hey, I have one more question for you, but first tell me how people can find out more about your firm, O'Malley Tunstall.
Well, you can find us on our website, which of course is www.o'malleytunstall.com. You can reach us at 252-823-2266. We have Joe, my partner, does personal injury work, so that can involve anything from bouncy house cases to car injuries to truck accidents to construction case accidents. We have other law firms that we partner with, for instance, in medical malpractice cases. And we have, now I'm primarily doing the Social Security work, but we have 3 other associates in addition to Joe who are working on our personal injury side. And the other thing that, again, is part of the learning curve is if somebody calls us and it's not an area of practice that we have built a referral network so that we can try to send you to somebody who can help you with your particular issue. So the network of professionals that we work with is also amazing. And we get referrals from other professionals because of the type of work we do. So those relationships that we built up over time make a big difference.
Okay, awesome. Hey, last question for you. You just mentioned something that you learned that from working that you didn't learn in law school. If somebody who, maybe a young person who's you think is kind of an impressive individual came to you and said, I really want to get into law, maybe even Social Security law. What could you tell them that only you would know based on, walking through the experience that they couldn't learn in law school?
Well, the first thing I always tell anybody going into law school is sign up to be the Barbary rep because it means your Barbary classes are free. And after you go through law school, then you have to go through a whole set of review classes just to study for the bar. Um, but what I would tell them is if they can do internships in different practice areas, that's good, because I went into law school assuming I wanted to do one thing and I've done something very, very different. If you have the opportunity to take any business classes, not that law school isn't hard enough, it is, but an MBA would make a big difference in you understanding the back office part of it, because being good in court isn't the same thing as being good in business. And understanding how income goes, how business loan works, all of those things, learning how to deal with personnel appropriately, things that you can ask, things that you can't ask. All of that would be tremendously helpful into making you more well-rounded and less seat of the pants.
Sure, sure. Hey, Susan, it's been great to talk to you. Thank you so much. Really informative and insightful. I appreciate your time today.
I appreciate you talking to us, and reach out to us anytime.
Okay, thanks so much. So long,
All right.
everybody.
Thanks for listening to 15 Minutes. Be sure to subscribe, and we'll see you next time.